Have you ever wondered what happens when someone is arrested and why they might get released on bail? Bail is a critical part of the criminal justice process, but its purpose and how it works can be confusing. In this video, we'll break down everything you need to know about bail, from its definition to how you can get it. Whether you're facing criminal charges or simply curious about the legal process, this guide will provide clarity. Stick around as we explore the different types of bail, how it's set, and how you can navigate the complexities of this crucial part of the legal system. What bail is and what it isn't. Bail is often misunderstood, so it's essential to know that it's not a free pass to avoid a trial. At its core, bail is money or property pledged to guarantee that the defendant will appear in court for their scheduled hearings. If the defendant fails to show up, they forfeit the bail, and a warrant for their arrest may be issued. However, bail does not mean that the defendant is free of their charges. It's just a conditional release to allow the accused to prepare for trial while adhering to court-imposed conditions. Understanding the difference between bail and a bond is crucial, as many confuse these terms, particularly with bail bondsmen involved in the process. Types of bail. Which one applies to you? There are several different types of bail, each suited to different circumstances. Cash bail is straightforward. The full amount is paid upfront to secure the release. Property bail uses real property, like a house or land, as collateral. Surety bail is where a bail bondsman steps in, typically requiring only a percentage of the total bail to be paid. If the defendant fails to appear, the bondsman is responsible for the full amount. Release on recognizance, where OR, allows a defendant to be released without any money if the judge believes they are not a flight risk. Lastly, citation release is used for minor offenses, where a citation is given instead of being held in custody. How is bail set? Who decides the amount? The amount of bail is determined by a judge during a bail hearing. Several factors are taken into consideration, including the seriousness of the offense, the defendant's criminal history, ties to the community, and the likelihood of fleeing. Ultimately, it's a two-step inquiry. Are you a flight risk or a danger to society? A judge may also refer to a bail schedule, which sets predefined bail amounts based on the crime committed. The judge's role is to balance ensuring the defendant returns to court while not imposing an unreasonably high bail amount. If the bail is set too high, it may be seen as unconstitutional, but if it's set too low, it might not serve as an effective incentive to appear in court. Can you challenge the bail amount? If you feel that your bail amount is excessive, there's an opportunity to challenge it through a bail reduction hearing. In this hearing, your defense attorney can present evidence to argue that the set amount is too high based on your circumstances. Factors such as the nature of the charges, your financial situation, ties to the community, and prior criminal history will all be considered. A successful bail reduction hearing can lead to a lower bail or even a release on recognizance. It's crucial to have a skilled attorney to navigate this process, as a judge may be more likely to reduce the amount if you have strong arguments in your favor. The role of a bail bondsman. A bail bondsman plays a critical role if you cannot afford the full bail amount. They act as a third party who posts the bail in exchange for a non-refundable fee, typically 10 to 15% of the total bail. This allows the defendant to secure their release without having to come up with the full amount of cash. However, the bondsman will often require collateral, such as property or assets, in case the defendant fails to attend their court hearings. If the defendant skips bail, the bondsman is responsible for paying the full bail amount to the court, so they will take aggressive measures to ensure the defendant returns to face charges. What happens after bail is paid? Once bail is paid, the defendant is typically released from custody, but they must adhere to certain conditions of release. These may include regular check-ins with a probation officer, staying within a specific jurisdiction, or abstaining from alcohol or drugs. The defendant must also attend all court hearings and comply with any other requirements set by the court. If these conditions are violated, the court has the authority to revoke bail, which could result in the defendant being taken back into custody. It's important for defendants to fully understand these conditions to avoid unintentional violations that could jeopardize their release. Bail versus jail time. What are your options? In some cases, bail may be denied or set so high that it's unaffordable. If this happens, the defendant remains in jail while awaiting trial. The reasons for bail denial include being charged with serious offenses, such as murder or sexual assault, or if the defendant is considered a flight risk. Staying in jail while awaiting trial can have significant consequences, not just in terms of personal freedom, but also in the time it takes to prepare a defense. A defendant who is in jail may face challenges in contacting their attorney, gathering evidence, and developing a case strategy, potentially affecting the outcome of the trial. How long after arrest will bail be set? Bail is usually set within 24 hours of an arrest, although the exact timeline can vary depending on the jurisdiction and the severity of the charges. After the arrest, the defendant typically appears before a judge in a bail hearing, where the judge will set the bail amount. If the defendant has not yet appeared before a judge, they may be held in custody until their first court appearance. For minor offenses, some jurisdictions have specific bail schedules, where the bail amount is automatically set based on the offense and doesn't require a hearing. However, in more serious cases, the judge may take additional time to evaluate the circumstances. Can bail be revoked? Bail can be revoked if the defendant fails to meet the conditions of their release. Common reasons for revocation include failing to appear in court, committing another crime while on bail, or violating other release conditions. If bail is revoked, the defendant will be taken back into custody and may face additional charges for violating the terms of their release. In some cases, bail can also be revoked if the defendant is deemed to pose a danger to the community. If you're in a situation where your bail is at risk of being revoked, it's important to work with your attorney to ensure compliance with all terms and avoid potential legal trouble. The impact of bail on your case. Being released on bail can significantly impact the outcome of your case. With the freedom to prepare a defense, gather evidence, and meet with an attorney, you have a better chance of mounting a strong legal challenge. Jail time before trial often limits your ability to build your case effectively. Moreover, being out on bail allows you to continue working and supporting your family, which can reduce the personal and financial strain of being incarcerated. Psychologically, being home with family and friends also provides emotional support during the stressful period leading up to your trial, which can positively affect your overall well-being. Navigating the bail process can be tricky, but having an experienced criminal defense attorney by your side can make a significant difference. A skilled attorney can help you understand your options, advocate for a fair bail amount, and guide you through the complexities of the legal system. Whether you're seeking a reduction in bail or challenging a denial, professional legal advice is crucial to securing the best possible outcome. Remember, your freedom is at stake, and with the right support, you can ensure that your legal journey begins on the best possible footing. For more insights, make sure to subscribe to Criminal Defense Attorney Tips for expert advice on navigating the criminal justice system.